Sean the Swanvillan here, and I don't mind telling you I'm a little bit afraid at the moment, anxious, trepidatious. It's probably the best word. I'm not afraid that something bad is going to happen, so much as I'm afraid that making good things happen is going to require a lot of work, which is all a learning experience. But well, here's what's going on. I filed a lawsuit with the federal government in federal court against the county of Waldo, where I live, Waldo County, Maine, and 4 of its deputies. And I filed that about just over a year ago. Originally, it was dismissed because of technical reasons, basically. And the judge kind of was very critical, it seemed at first to me, but she was listening to her or taking her criticism into account, reading what her dismissal, her reasons for dismissal, clued me into exactly what I needed to do to refile it, because it was dismissed without prejudice, which means that you can that it can be refiled, or if it's a criminal case, that if something is dismissed without prejudice, it can be brought again without being double jeopardy, for example. And in my case, though this is civil, of course, I refiled it at the beginning of the summer, and it went right through very quickly this time. It took a long time to hear back the first time. This time it sailed through and was served just over 60 days ago to the county of Waldo, and its deputies were served. Well, they waived service, which just means it's a way to avoid having to pay the service fees. And the sheriff's department is the one that does the serving around here anyway. So I guess it's good they didn't pay themselves to get served. And but yeah, that was 60 days ago roughly. And so they got the complaint, they got my lawsuit, and now I've got the answer from them. I got something from the court, and this is an answer from the law firm that the county hired to defend themselves against me, and it's got quite a bit of stuff in it, quite a bit of paperwork. And I don't have a whole lot of time to deal with it and respond to this. I suppose depending on what it is. Excuse me. But anyway, that's what I'm unboxing is the answer to my lawsuit from the law firm, and what the court, presumably what the court has to say about it. The Office of the Clerk, United States District Court in Bangor. Oh, actually, this is out of Portland, but same system. Anyway, so what the lawsuit is about, just briefly, is I used to work at a store. I live in Swanvillan, Maine. Used to work at the only big business of note in town, which is a grocery store, which has a kind of a monopoly because it's the only one in the area for many miles around, 10 miles at least. And so it's kind of the only employer around. I worked there for a while, year and a half, something like that. I was harassed the whole time I worked there. I finally brought it to the attention of management. 3 days later, they basically fired me, which is all legal in Maine, but not very nice. So I started protesting against it, and right off the bat, Deputy Ottinger of the Waldo County Sheriff's Department came and told me, he trespassed me from their property, from the store's property, which, okay. But then he also told me that I wasn't allowed to protest for 24 hours on public property nearby. He gave me a warning to that effect, which at the time I didn't question, but of course is not. The cops can't just, except under special circumstances, certainly can't vacate an individual from public property just on their own volition, without a court order or something like that. But that's what he did. And then, but I continued protesting, and then Deputy Moody came and cracked down on me, told me I couldn't talk while I was protesting, basically. I couldn't talk to any customers. And Deputy Perez got involved by the owner of the store's grandson repeatedly threatened me, and I reported that to this Deputy Perez, and he wouldn't do anything about it, but he was happy to give me a warning, a warning not to be cause a disturbance, which there's no causing a disturbance statute in Maine. He also trespassed me or rather gave me summoned me for trespassing at the store, allegedly, although I hadn't, and the case was dismissed. I had gone into their parking lot area, but it's not far enough that, part of that is, part of their area there is public, and anyway, yeah, I was kind of on the borderline there, but anyway, that was dropped. But he wouldn't do anything about this guy who had repeatedly threatened me. There's a phone call. The first couple of videos on this channel are related to all this. And then after, I think, less than a week of protests, like 6 days, I was arrested for terrorizing by Deputy Moody and another deputy called Tozier. And they arrested me. It was because of a YouTube video I had made after being harassed and threatened for a while and fired by these people, treated like dirt by them for a while. I got on and ranted about it on YouTube. And I used some violent imagery. Nothing that was a credible threat. I said, if it were legal, that if it was the law, that this, such people that fired you for reporting harassment were, I forget exactly, but I qualified it multiple times. If it were the law that was the case, and they were brought to trial over it, and they were found guilty, and the punishment was the death penalty, I would kill them, or I would act as their executioner. But I'm not going to do it, of course. I'm just venting. I'm not going to do anything illegal. That's basically not a credible threat. It was couched in so many layers of hypothetical nonsense. And again, it was very clear. I stated that I was venting and the like. It was obvious it wasn't an actual threat, no credible threat. Nobody took it seriously, but it gave them an excuse to have me arrested. And the owners of the Swanvillan grocery had some sort of in with the sheriff's department. It sure seems like to me. And beyond just the fact that they're a business, I think they knew the sheriff at the time, Trafton, personally or something like that. He testified for them, lied, perjured himself for them at one point later on after all this had happened. So, yeah, I was arrested for felony terrorizing, and those things back here that you can kind of see are antique heirloom single-shot hunting rifles, and you can see them a little bit more clearly in the video that or it might not have even been the same video I made the alleged threats in. It was just a video where, which was related, or maybe you could see part. I think that I think you can see part of it in the video that I made the alleged threats in. Anyway, it was all absurd, but they used that as an excuse. They said, well, that was the use of a deadly weapon, to back up my terroristic threats, to have the law radically changed in an absurd way so that eventually, after due process under this new, yeah, but they felony terrorizing, tried to send me to prison for 5 years. DA was all 100% on board behind it. And, but the case basically fell apart. Ended up being a token day in jail and a year in probation that I agreed to because my attorney didn't even bother to call witnesses for the defense. Well, all a mess. The judge himself admitted, agreed during sentencing. I said I didn't say anything illegal, but what I said was really awful and poor choice of words. And he said, "Well, you might not have said anything illegal, but what you said was deplorable. So I'm going to sentence you to." I mean, it basically admitted that I hadn't broken the law, but it didn't matter, I guess. Anyway, so that's what this lawsuit is about. Is about them cracking down on my rights in those various ways, not having due process to arrest me, which makes it an unlawful seizure, and not providing me with equal protection. I was repeatedly threatened by somebody who had admitted threatening me credibly, certainly a lot more credibly than my threat was, and it was done personally by a group of people surrounding me at one point, young males, So, yeah, it was all, and I had hoped having a active lawsuit against these folks would, encourage them to behave a little better. Excuse me. But it does not seem to be doing so because they're still, this trite thing happened if you... Anyway. They're not behaving any better. But then again, they're cops, right? And this was my introduction to learning just what trash cops are. Absolute oath-breaking trash. Every single one of them are awful. So, now, real quick, predictions. I'm going to guess this is not a settlement offer. The case was good enough to proceed in federal court. It had enough merit to do that, but as far as, well, yeah, I doubt this is a settlement offer. I'm sure they're going to try at least to get it dismissed or whatever. My guess is what it is obfuscation, an attempt to baffle me with a bunch of legalese bullshit, basically. Just, 40 or so, whatever it is, pages of nonsense. I'm guessing, maybe not. We're about to find out. I'm about to find out with you. And this sat in my mailbox for a day or two. Then I spent a day and a half trying to find a good... I was in Belfast, the next town over, where there's a public library and a few other places where there's half-decent Wi-Fi, but I couldn't get good enough Wi-Fi to do a live stream. I tried several times, and it just kept glitching on me. So, I put it off for whatever that is, 3 days-ish, and then trepidation has kept me from opening it. I guess I wanted to do it live, so I might have some sort of like moral support or something. I guess not exactly that. I'm not. Yeah, don't be afraid, or be very afraid. I don't know. We'll see. This is going to be interesting, and it's all a learning experience. And and so I'm guessing. Usually, you only have to answer these things. Apparently, you have 21 days, and so some part of that's already eaten up, and some part of it, will be taken up in mailing this stuff back, because I can't hand deliver it to Bangor or Portland. So I've got 2 weeks-ish to figure out when all this is. So let's see. I can't decide whether to start with the lawsuit stuff or the court stuff, but the court is what has any kind of final say in things. So I think, no, I know, I'm going to start with the court thing. Okay, let's see. Docket text. This is from the U.S. District Court, District of Maine, Floyd v. Waldo County et al. Waiver of service. Turned. Yeah, okay. So these are the copies of the, I think I mentioned a waived service, which just means instead of being served, they just accepted it by mail. They said, you don't have to serve us, we'll just accept it and sign these papers proving we accepted it. And that gives us an extra 30 days instead of 30 days to give Mr. Floyd, an answer. They have 60 days. So this just is confirming that all that. So okay, so these are completely unrelated, as it turns out. Okay. But this has got to be the answer, I believe, because it was good. So the court hasn't confirmed anything yet, but this has got to be their answer. Okay, so let's see here. Dear Mr. Floyd, from Monahan and Larry LLP, attorneys at law, out of Portland, kind of a fancy law firm, that the county hired to defend themselves. It says, Dear Mr. Floyd, please find and close defendant's motion to dismiss with incorporated memorandum of law, which we filed with the court via, electronically, basically, ECF. Okay, defendant's motion to dismiss. Okay, so they talk about how I filed it originally. I don't know how they know that, really. Because it never should have gotten past the judge, but anyway. And it talks about when I'm claiming. And then it talks about how the case was dismissed on May 10th, 2024. Recommended it was dismissed. And then on July 5th is when I refiled it. And that's when it was there. And so they're going to refer to that as Floyd 2. The factual affirmance in the complaint are nearly identical to those in the complaint in Floyd 1. Okay. Notably, in both pleadings, plaintiff alleges that torture would be arrested plaintiff for terrorizing. Compare Exhibit 1. Plaintiff alleges that the complaint that he was indicted and tried for felony terrorizing further is granted a plea deal during the trial. So, okay, yeah, they're just kind of restating everything. But here, then we have something called standard of review. So, okay, so there's a federal rule, 12b-6, allows dismissal of an action for failure to state a claim upon which relief could be granted. Okay, I already went through this with the judge. So they're trying to yeah, this is all the same stuff that the judge already told me. I'm not sure why they're... Okay, yeah, this is definitely going to... Finally, the First Circuit has held that an affirmative defense such as res judica may be raised in a motion to dismiss under Federal Rule of Civil Procedure 12b-6 when the facts establishing the defense are clear, are clear on the face of the plaintiff. This, yeah, I'm sorry. This is going to take some serious study. Okay, argument. The plaintiff's claims are barred by claim preclusion. So, in light of the order and judgment of Floyd 1, claim preclusion bars the plaintiff's claims against all. I don't see how. When assessing a preclusive effect of prior federal court judgment, the court applies federal claim preclusion law. Okay, see, I don't know what that is. Second, the causes of action the plaintiff asserted are sufficiently identical, related to those he has asserted, but it wasn't dismissed with prejudice. Are they? And then they say that, again, they're repeating what the judge said, plaintiff's complaint fails to state claims upon which relief could be granted, citing, I'm going to guess, Twombly. No, something else. Barrigo, Rivera v. Okay, I got to look that up. Albert. Yeah, this is this is what I'm going to be. This is going to be going through my head for the next 2 weeks, and it's going to be a great big giant learning experience. Okay, so but that's not bad. That's the end of that section. Their arguments, and then they have exhibits, which is just my yeah. So what they're saying is that, and then they just have the 2 different copies of my lawsuit. So their claim is basically, you filed this, and the judge dismissed it, but without prejudice. And so you fixed all the technical details in it. Well, they're not saying that, but that's what happened. And refiled it, but it's still the same suit. And all the stuff the judge said when she recommended dismissal the first time applies the second time, even though the judge didn't think so, and the clerk of courts didn't think so, because they, like I say, let it sail through. So I don't know what all that means. But I don't know. I'm a little less afraid now. Because I don't know. Who knows? Maybe. Well, I got to look all this up. All right. Yeah, lots of work, but that's okay. I do. This is a scary game I play sometimes, for no other reason than I often risk arrest. But yeah, not as bad as I thought. I don't. If that's it, and if that's it, then the next one. See, and I got at least a half a dozen more against the county. A couple against the state police, a couple of local ones, a couple against the attorney, or at least one against the attorney who screwed me over to start, got me into this mess. That's going to be a local one now, so that's different anyway. But yeah, okay. A little less scared now. I hope any of that's interesting. If anybody has questions, I guess, about this, I'll be delving. I guess if anybody wants to hear more, wants more content about this legal stuff, I kind of, protesting's kind of out, because if I protest in Swanville, people can attack me, and I get charged or summoned for a crime, but they don't. And if I protest in Belfast, they might just summon or arrest me on kind of a whim. I just don't know what's going to happen in either case. And those are the places I have access to protesting to. So, I guess I'm going to be doing well, I got lots of lawsuit homework to do anyway. All right, so thank you for listening and watching and putting up with my stomach grumbling. I don't know if that's coming over the audio, but yeah. And yeah, let me know what you think in the comments. Keep fighting. Peace.